only now told me that you are also pregnant, I have no alternative other than to terminate your employment with our company. The respondent company has itself anticipated the incapacity of the appellant on the sole basis of her pregnancy. The rule of audio alterum partem, translated in English as nobody should be condemned unheard. It is a very basic rule of principles of natural justice. It is an immediate requirement of principles of natural justice that before passing any adverse orders, such person needs to be granted an appropriate opportunity of being heard. If the order is passed by the authority without providing reasonable opportunity of being heard to the person affected by it adversely, will be invalid. Your lordships, in my humble view, audio alterum partem is a highly effective rule devised by the courts to ensure that authority arrives at a just decision, and it is calculated to act as a healthy check on the abuse or misuse of power. Its reach should not be narrowed and its applicability circumscribed. The maxim audio alterum partem constitutes two things. Firstly, the notice of the case to be met, and secondly, the opportunity to explain. This rule cannot be sacrificed at the altar of administrative convenience or celerity. For convenience and justice are often not on speaking terms. The right of the person to defend him or herself in the face of a decision potentially affecting his or her rights or interests necessarily implies that the person must receive prior notice of the facts on which the decision will be based. Failure to give proper notice is itself a denial of natural justice and of fairness. The concept of natural justice cannot be put into a straitjacket. It is futile to look for definitions or standards of natural justice. The only essential point that has to be kept in mind in all the cases is that the person concerned should have a reasonable opportunity of presenting his case, and administrative authority concerned should act fairly, impartially, and reasonably. Your Lordship, it is our argument that the principle of natural justice have taken deep root in the judicial conscience of our people, nurtured by several landmark judgments. They are now considered so fundamental as to be implicit in the concept of ordered liberty, and therefore implicit in every decision-making function.
Counsel,
Thus,
in the facts, please tell us where exactly your right to natural justice was violated. What is, we appreciate your, that's fine, but exactly, we want to know that where was your natural justice exactly violated? Your right to natural justice, you claim to be have been violated, right? Exactly, and where? How have you been aggrieved?
on para 4, page 1,
Yes.
that I could have exercised my right of option, and in the present situation would have aroused the respondent decided to terminate me as soon as they discovered that I am pregnant and has acted in prejudiced and biased manner.
So what do you think the company should have done? What is
The
just tell
alter,
us what.
at least they could have given me notice or an intimation.
Okay, that's your case. Yeah, please proceed. Yeah, please proceed.
Much obliged, Lordship. Where the statute is silent about the observance of principles of natural justice, such statutory silence is taken to imply compliance with the principles of natural justice. My lords, it is a matter of record.
Counsel, 1 minute. Just in furtherance to what you're saying, I really appreciate. You are not given notice is your case. We appreciate that. Now, this is a clear-cut notice to you on an admitted fact. It is not in dispute that you were hired in place of another person for the same reason. And secondly, it is not in dispute that due to the pregnancy, now the company may have to hire another person for being trained. When there are admitted facts before us, or which even you cannot dispute, then what do you feel is the role of natural justice? What is it that they had to hear you for? What is it that the respondent had to hear? Everything is admitted. The pregnancy is admitted, and the effect of your replacement is admitted. They're all on documents.
The council certainly understand the concern of the bench. My lords, I could still give options to work with them itself, and the way this could not be a prejudice. Hearing was to ensure that there was a balance of rights. There was that is my contention, your lordships.
So please proceed.
Hey, proceed without any agitation. You can doing well. Yeah.
Proceed.
Highly obliged, your lordships. My lords, it is a matter of record that before attributing the misnomer of incapacity to perform work upon the appellant herein, the respondent company did not offer even a single chance of hearing, consultation, or inquiry in this regard, therefore violating the principles of natural justice. Furthermore, it is my humble submission, your lordship, that the impugned order attaches stigma to every pregnant woman as being incapable to perform duties. It is humbly submitted, your lordships, that the impugned order is stigmatic in nature and treats pregnant women as incapable to perform the assigned duties. My lords, without even evaluating the risk associated or my choice to work, the impugned order has been passed against me. Your lordship, as a matter of fact, I am a childbearing woman and even my husband is no more. I was the single breadwinner of my family, and that in the times of COVID 19, where finding a job would cause undue hardships and irreplaceable damages. It is humbly submitted that the pregnancy is not a disability, but a natural consequence of marriage and is temporary in nature. To the contrary, the respondent company has dismissed the appellant for an endless term, and therefore it is contended that the dismissal for an endless term is arbitrary in nature. It is also argued that such an approach is stigmatic in nature and violates the constitutional mandate contained under Article 14, Article 16, and Article 21 of the Constitution. It is argued by the counsel for the appellant that the respondent company has attributed relative incapacity to perform the assigned work upon the appellant herein without receiving any complaint or accessing any performance or holding a departmental inquiry in this regard. Your lordship, in my view, myths and purely habitual assumptions about a woman's inability to perform certain kind of work are no longer acceptable reasons for refusing to employ qualified individuals or for paying them less in the modern society. It is also argued the pregnancy cannot be equated and aligned with any pathological disease for the simple reason that pregnancy is neither any disease nor any illness, and such different conditions cannot be compared at a same pedestal. If my lordships are satisfied with our submissions, I would
Also,
like.
we have one question. Now, see, we see from the facts that it was the company which came to know. It was the respondents who got to know that you were pregnant. Was it not your duty also to inform that you were pregnant? If you are if you are asking for a right, then you should also be fair enough for it, right? The facts are very clear that you never informed the company about it, the respondent about it. The respondent got to know through some other sources.
My lordships, I certainly understand the concern. It was not confirmed till that time that I was pregnant when I was appointed.
Even subsequently, you did not inform. You can see para 4, it's quite clear. So we have a principle of that, right, in law?
My lords,
To be fair, to claim a fair right.
My lords, I bow down to that, but it was not confirmed till that time when I was when I was appointed. It was not confirmed that I was pregnant. I only got to know about this later. Uh, just a moment, your lordships.
Take your time, please take your time.
My lordship, I bow down to that, and even after that, I was in doubt and I was not confirmed. When I confirmed that, before I could inform them, they dismissed me. Before I could inform them, they dismissed me. When I was appointed, I was not myself not known that I am pregnant. But before I could inform them, they dismiss me and therefore violating the principles of natural justice.
Please proceed.
Yes.
I would like to proceed to the prayers. In the light of the facts and circumstances stated above, it is most respectfully prayed that this honorable court may be pleased to set aside and quash the impugned order dated 30th July 2020, dismissing the appellant from her services on the ground that her pregnancy, set aside and quash the judgments of learned labor court and honorable high court affirming the impugned order, direct the respondent company to allow the appellant to join the services with all consequential benefits and back wages. Any other orders or directions as this honorable court deems fit in the interest of justice and for this act of kindness and justice, the appellant as is duty bound shall ever pray. The counsels on behalf of the appellant believe that the judgment of this honorable court shall be in the best interest of the justice and for all the parties. Your lordships, it was indeed a pleasure arguing before this court. With that, I bow down before the honorable court.
Counsel, your prayer 3, does it include maternity benefit also?
I certainly understand the concern. No, Your Honor, no, Your Lordship.
There is no prayer for maternity benefit.
No, Your Lordship, we are not contented. That is not our contention to claim the maternity benefit. We are seeking the protection under Article 12.
So what would be the subsequent relief then?
Lordship.
Prayer 3, please interpret prayer 3. Paragraph 7, prayer 3, prayer number 3.
We are only claiming reinstatement with back wages. We are not claiming the maternity benefit.
Okay. I thought your whole endeavor was to claim maternity benefit before us.
No, Your Lordship, it is not our contention.
So you mean to say it's a consequential benefit?
Yes, Your Lordship.
Your Lordship, greetings to the bench. Counsel for the respondent seeks permission to approach the dais.
1 minute, I think she's yet to conclude, no, Speaker?
Hmm.
So your time is over then.
Yes, Your Lordship.
Okay, thank you.
Counsel seeks permission to approach the dais.
Please proceed, counsel.
Greetings to the bench. Counsel appearing for the respondent in the case of Kangana versus Antariksh Logistics Asgard Limited seeks permission to refer to the learned bench collectively as Your Lordships.
Please proceed, counsel 1.
Much obliged, Your Lordships. Your Lordships, counsel seeks permission to state the facts of the case.
I think we all concur. You may proceed to the issues. We are quite aware of the facts of it.
If Your Lordships are well versed with the facts of the case, counsel seeks permission to state the contentions.
Please do.
Much obliged, Your Lordships. Your Lordships, Counsel 1 will be addressing the first contention that it is not discrimination on grounds of sex, contrary to standing orders for the respondent to have dismissed the appellant, for which Counsel seeks to reserve 21 minutes of this learned bench's time. Counsel 2 will be addressing the second contention that the dismissal of Ms. Kangana did not violate human rights, which are protected under the Constitution and other human rights treaties and conventions signed and ratified by Asgard, for which my learned co-counsel seeks to reserve 21 minutes of this learned bench's time as well, reserving 3 minutes for rebuttals.
Please proceed.
Proceed.
Your Lordship. Your Lordships, sex discrimination is an extensive subject of disquisition. Amid the plethora of interpretations, the fundamental step is to understand the meaning of sex discrimination and what are the key components which entail the manifestation of this practice. Sex discrimination is understood as treating someone, an applicant or employee, unfavorably because of that person's sex, including the person's sexual orientation and gender identity. Your Lordships, in order to cleanse the respondent of the sin of discrimination, their argument that the petitioner's dismissal was not sex discrimination builds itself through the chronology of 4 considerations. Firstly, the fact that the petitioner was not suitable for the job role. Secondly, the fact that she was a probationer. Thirdly, the fact that after finding her unsuitable and being aware of their rights an employer of a probationer, her resultant termination was termination simpliciter. And finally, the fact that anyone in the same position would have been let go regardless of sex. Your Lordships, when discussing firstly the suitability of the petitioner, one cannot ignore the circumstances which facilitated the creation of the role she would come to fulfill. The petitioner had applied to a position that was made available due to a permanent employee herself going on maternity leave. The petitioner being pregnant made her instantly unsuitable for the role she was about to take up. Your Lordships, the petitioner having gotten pregnant only 1 month apart from the employee she was to replace naturally leads to virtually the same maternity time leave time period for both of them. Miss Rakhi going on maternity leave in circa December and Miss Kangana going on maternity leave in circa January of 2021. This, Your Lordships, clearly shows that the petitioner is unable to fulfill the main object of her employment in the first place, that is filling in for Miss Rakhi. Your Lordship, here a distinction needs to be drawn. The topic of pregnancy is an emotive one, but the peculiarities of the instant case also needs to be highlighted. The respondent, in good faith, communicated their need for an employee to fulfill the role played by Miss Rakhi, who was due to go on maternity leave. However, the pregnancy of the petitioner was not inquired by the respondent in order to respect the privacy of the petitioner, as such questions were deemed to be an affront to the modesty of a woman. Your Lordships, the fact of her pregnancy was not known before her employment, and had it been known, she would have still been hired, as not hiring her would have amounted to discrimination. Counsel thus humbly argues that the petitioner's right would be violated if she were not hired due to pregnancy, but the employer exercised their rights while terminating her services while she was on probation after finding her unsuitable for the job due to lack of material time on her part. Your Lordship, counsel brings the learned bench's attention to the fact that there is a distinct distinction between suitability and competence. In regards to all the facts given in the factual matrix, indeed it speaks of the competence of the petitioner, but it must not be confused with the suitability of the petitioner to the role that she was to fulfill. Your Lordships, according to the Allahabad High Court, in the case of Muhammad Zahur versus Committee of Management, a case decided in 1997, where there were two appellants who were both provided an extension of more than 2 years to their probation and were then dismissed based off of unsuitability at the lapse of their extension. The object of appointing a probationer is to test their suitability. Thus, it can be concluded that the termination was due to unsuitability of the petitioner. Your Lordships, the second aspect of the petitioner's unsuitability for the job role could be her consideration for being granted work from home benefits. A natural conclusion one runs into going down this line of thinking is that if the job role would allow the work from home provision, it would have been granted to Miss Rakhi herself, Your Lordship. Your Lordship, the Industrial Tribunal noted that the employers had shown that the reasonable needs of their business required that the person recruited to cover for Miss Rakhi during her maternity leave be available throughout the time of said maternity leave, helping counsel establish that the role is not one that could be fulfilled by an employee working from home. Your Lordships, counsel guides the learned bench to the fact that the factual matrix remains absolutely silent on the nature of her role in the imports department. Your Lordships, the respondent is a logistics company, an industry which is especially affected by a pandemic. To highlight the same, counsel cites a report by the International Finance Corporation titled The Impacts of COVID-19 on Logistics, which elucidates the stresses on a logistic company during a pandemic like the COVID-19 virus. The stresses mentioned here, Your Lordships, are apart from the stresses that all businesses have had to endure due to the pandemic, like the threat of a workforce that may shrink even further due to employees contracting the deadly virus, essentially crippling a department like the one employing the petitioner with just 4 employees, Your Lordships. In addition to this, according to the Karnataka High Court, in the case of Prachi Sen versus Ministry of Defense, a case of the Karnataka High Court decided in 2022, where the petitioner worked as a senior engineer in a research facility and claimed her right to work from home under the Maternity Act Amendment of 2017 as an excuse for leave without permission. The Honorable Karnataka High Court held that the work from home provisions are up to the discretion of the employer and if the work profile allows for them. Your Lordships, the second consideration of the respondent's case is that the petitioner at the time of her termination was a probationer, and the effect of this fact on the case is twofold. Firstly, there was a reasonable parameter set by the respondent, which was of replacing Miss Rakhi while she was on maternity leave. This sets a parameter for her suitability for the job. In the case of Dr. Padiyar Memorial Homeopathic Medical College versus State of Kerala, the Honorable High Court of Kerala decided in 2006 that where the facts of the case being the appellant was a lecturer who was promoted to the post of professor on probation, but the promotion was not approved. Your Lordship, he sued and was made a professor during the proceedings and then approached the court to claim seniority since 2003. This has been cited in the memorial as case number 10 in the table of cases and fourth page of the memorial. Your Lordship, the Honorable High Court of Kerala held that probation is a period where an employee can assess the suitability for the job of a probationer. It is clear that she was not eligible for her job role, and the respondent was well within his rights to terminate a probationer found unsuitable for her job role. Secondly, Your Lordships, by virtue of being a probationer, the petitioner has no right to claim a confirmation, as has been held in a plethora of cases, like in the Andhra Pradesh High Court case of K. Dasarath versus Labour Court.
Counsel,
Your Lordship,
we,
indeed, Your Lordship.
first thing we would like to clarify is you're before a full bench of the Honorable Supreme Court here. And so
Much
far
obliged.
you're relying on High Court. So we would assume that those cases are yet to attain finality by principles before us. So these are cases which are yet to attain finality until and unless they are of such nature that you don't have any other citations of the Supreme Court, firstly. So it may at the most have persuasive value because they are subject to be impugned before us anytime, firstly. And secondly, with reference to your difference between suitability and competency, wasn't so now that you know that she is pregnant, you're disputing your own recruitment against her, which we feel is not fair because you had recruited her as a replacement. So the moment the facts of the case say that you have recruited her as a case of replacement, we presume that suitability was also included there, as otherwise you differentiate competency and suitability in the facts of the case,
Indeed, Your Lordship.
right? And
Uh,
when it comes to the other cases you're relying upon, the the appellants have specifically taken a ground before us that you did not even give a notice to them. So the
much obliged,
cases
Your
which
Lordship.
you're relying upon, you have to convince us firstly that they are cases which the establishment did not give a notice to the employee, firstly. And
Much
secondly, you
obliged, Your
have
Lordship.
to differentiate between competency and suitability qua the facts of the case before us.
Much obliged, Your Lordship. Your Lordship, addressing the first query of Your Lordship, we are assuming we are assuming the judgment cited by counsel today as having persuasive value on the learned bench, and at the we will further cite cases that will help establish our case held by the Honorable Supreme Court of India in further arguments.
So please proceed.
Uh, Much obliged, Your Lordship. Your Lordship, in the case of K. Dasarath versus Labour Court, the by virtue of being a probationer, it was held that the petitioner has no right to claim confirmation, meaning that her rights were limited to that of a probationer, the termination of whom does not require a cause to be stated, which was provided to the petitioner by the respondent in good faith, Your Lordship.
Counsel, is
Furthermore,
that a case of dismissal on maternity on the ground of maternity?
Your Lordship, K.
Case law
Dasarath.
you're relying upon, is it a case law where she was dismissed on ground of maternity?
Indeed not, Your Lordship. But,
Uh,
Your Lordship, it is humbly pleaded that the petitioner was not dismissed on the grounds of maternity, even in this case. It was due to her unsuitability for the role that she would come to occupy.
Okay, so it is your case that you dismissed her due to unsuitability, not the
Much
pregnancy.
obliged, Your Lordship.
I'm afraid the facts are different.
Your Lordship.
Yes.
Kindly persuade us on that.
Your Lordship, as has been argued by the council, it would have been discrimination again on the grounds of sex if we would have denied employment to the most competent person who had come for the job interviews uh, due to any grounds of maternity or pregnancy. And the fact that an employer cannot ask an employee of such intimate details has been held in the case of Neera Mathur versus LIC. Thus, Your Lordship, it is humbly submitted that it would have been discrimination to not hire a woman based off of the suspicion of pregnancy or maternity. But the separation comes with the fact that an employer is well within their rights to dismiss a probationer based on unsuitability.
Counsel, kindly read the impugned notice. No, what has been impugned before us? Paragraph 4 of your facts, the last 3 lines. Your notice to
Much
the
obliged, Your
employee.
Lordship.
Your
Your
notice to
Lordship,
the employee.
you will recall that at your interview some 4 weeks ago, you were told that the job for which you applied and were given had become available because of one of our employees becoming pregnant. Since you have now only told me that you are also pregnant, I have no alternative other than to terminate your employment with our company.
Yes. So, do we find the word competent or unsuitability in the notice or
Your
in your order?
Lordship, Your Lordship, the
Where do we
termination.
find the word unsuitable or competence in your order of dismissal?
Your Lordship, we are not claiming that she was incompetent. We are claiming that she was unsuitable. And furthermore,
Yeah, where is
the
that
term,
in the?
much
Yes, where
obliged,
is
Your
that?
Lordship. Your Lordship, it was implied in the termination letter. Your Lordship, the termination was carried out through a letter to the petitioner stating cogently and clearly that the reason for the termination was unavailability of the petitioner for maternity leave of Ms. Raki. Your Lordship, though we may not have the gift of the gab to express it, there was no malified intention between the reason for her being being found
Then how can it be
unsuitable.
a simpliciter termination
Your Lordship,
if that is the argument?
Yeah.
pardon, Your Lordship.
No, no. Okay. Then if that is the argument before us, then how can it be a simpliciter termination?
Your Lordship, the argument in question being,
No, your case is that it is a termination simpliciter.
much obliged, Your Lordship.
And in this background, how do you convince us that it is a termination simpliciter? If you
Your
had to
Lordship,
interpret.
much obliged, Your Lordship. Your Lordship, the legality of our decision can be seen in the Supreme Court of India case, Pavanendra Narayan Verma versus Sanjay Gandhi, PGI of Medical Sciences. This was a case decided in 2002. In the cases of table of cases, it's the case number 12, and
Counsel,
it's
they're different on facts, counsel. You have to convince us on your facts.
much obliged, Your Lordship. Your Lordship, here we're trying to not point towards, we're trying to point towards the definition of simple termination and stigmatic termination as was given by the Supreme Court of India. Here, the Apex Court of India observed that when a probationer's appointment is terminated, it means that the probationer is unfit for the job, whether by reason of misconduct or ineptitude, whatever the language used in the termination order may be. Although strictly speaking, the stigma is implicit in the termination, a simple termination is not stigmatic. Termination order which
You're reading
explicitly
paragraph
states,
29,
Your
if I'm
Lordship.
not wrong. You're at para 29 of the judgment, if I'm not wrong.
Uh, Indeed, Your Lordship.
Yeah, continue. Please read.
Your
Please read.
Lordship, a termination order which explicitly states what is implicit in every order of termination of a probationer's appointment is also not stigmatic. In order to amount to a stigma, the order must be in a language which imputes something over and above mere unsuitability for the job. Your Lordship, it is humbly submitted that that the respondent has made it clear that the lack of material time and the unavailability during Miss Rakhi's pregnancy was the reason for why she was found unsuitable. As we have time and again seen in the factual matrix, incompetence or discrimination on the grounds of sex was never the grounds used by the respondent. Your Lordship, furthermore, the fact that the petitioner was found to be unsuitable is one whose importance cannot be minimized, as it is up to the discretion of the employer to decide the efficiency of a probationer, as held in the case of DTC versus Premnath by the Honorable Delhi High Court.
Counsel, how do you presume all this even without giving her an opportunity to convince you whether she's suitable or not competent? Even other ways, let us setting aside let us leave that apart because we are still not convinced it falls within the definition of paragraph 29. Because
Much
what you are arguing is a different issue, but what has actually happened in your notice is a different issue. Because if you were to go by your argument, then it is not inconsistent to the notice that has been the order of dismissal. I'm sorry, the dismissal that has been issued by you. But
Yeah.
however, you have to give her a chance to the first thing you would do, right? They have a very good, that is basic principles. All of us are aware. It's natural justice. You could have just given her a one sentence notice or a show cause that we have learned that you are pregnant. You please appear before us and tell us what you have to submit. That would have at least given her an opportunity in all fairness to prove. How can you on your own prove that she is not suitable, she is not competent after you having hired her, fully being convinced that she is a perfect replacement?
Your Lordship, Council humbly states that in the case of Progressive Education Society versus Rajendra, the Supreme Court of India has held that unless a stigma is attached to the termination or probationer is called upon to show cause for any shortcoming, which may subsequently be the cause for termination of the probationer service, the management or appointing authority is not required to give any explanation or reason for
Exactly. Now
terminating.
you're exactly.
Yes.
So you cannot take the ground of unsuitability and competency. That's exactly what we are telling you.
Yes.
That's exactly what we are saying.
Ah.
Your
We are
Lordship,
with you on
Although
the
you
same
are
thing.
not directly discriminating the matters, but indirectly you are discriminating to the employee.
Wow,
indeed
if you,
not, Your Lordship. Your Lordships,
if you
there
take
was.
this ground, then if you have to convince us with this on natural justice, then you
Your
have
Lordship.
to let us and interpret the language used by you in the dismissal.
Your Lordship. Your Lordship, the as stated earlier by the council, that the language implies the unsuitability due to her unavailability during Miss Rakhi's maternity leave, giving her an
In other
opportunity.
words, can a simpliciter order imply a stigmatic approach?
Indeed, not, Your Lordship. And the argument is that this termination order was not stigmatic. In fact, it was not stigmatic because there was no other, there was no, we did not impute anything over and above her mere unsuitability.
Yes, counsel, that is why we are asking a very simple question. Your time is also running
Indeed, Your
out.
Lordship.
See, if it is your case that it was an order of simpliciter dismissal, then it was on the ground of pregnancy,
Your
which is
Lordship.
prima facie on the face
Yes.
of reading the dismissal order per se,
Indeed,
right?
not, Your Lordship.
And
Indeed.
if it is your case of pregnancy, then she has a case under the Maternity Benefit Act. We have to hear her under the Maternity Benefit Act. But if you say that your dismissal order was for unsuitability or for any other ground, then it cannot be a simpliciter order of dismissal.
Your
Now, one
Lordship.
thing I will like to mention here, one thing I would like to mention here, that if you are going through dismissing on the ground of inability or incapacity to doing the work, then you have to give the chance to explain yourself ki why you should not be dismissed from the service. And
Uh,
if you are terminating on the ground of pregnancy, then you have not given any chance. That is the
in,
reason.
Indeed not, Your Lordship. Your Lordship, according to the
Uh,
Delhi High Court, in the case of Mahavir Singh versus Delhi Transport Corporation, the Honorable Delhi High Court held that the opportunity to be heard will not be imperative while terminating the services of a probationer. Your Lordship, excuse me, Your Lordship, this is due to the mere the nature of probation, being that it is to test the suitability of the probationer.
That is
See,
another thing. That is another thing. In this case, matter is not regarding the suitability or probation period, ki whether they are suitable for the job or not. The Miss Rakhi is went to the for on maternity leave. It means she was absent. That is not a ground ki she was incapable. Then you have appointed and replaced to the Kanika or some other employee. That is the another ground. The,
Pardon, Your Lordship.
that case is not relevant to this matter.
Your Lordship,
Here, matter is not the incapability or capability. Here, the discrimination. Why you have dismissed to the employee? On what ground you have dismissed?
Your
That
Lordship,
is the only reasons. Ki either on the basis of incapability, either on the ground of she will be absent also because she is pregnant. You have come to know.
Your Lordship.
That is the main reason.
Your Lordship, we're trying to contend that there are two separate concepts running parallelly here. Firstly, we have the fact that she was pregnant. Discrimination against her based on of her pregnancy would have happened if she would not have been given a job and would have been asked if she was pregnant or not, and the most competent person coming for the job interview wouldn't have been given the job due to a pregnancy. That would have been discrimination, Your Lordship. But now we have come into the universe of the employer having the right to dismiss a probationer without without giving without giving a reason, because the nature of a probation is to find the suitability or is to come to terms with the suitability of the probationer, Your Lordship. Your Lordship, may the council continue with their arguments?
Yeah, sure.
Much obliged,
Proceed.
Your Lordship. Council would also like to add that in regards to the liability of the respondent under the Maternity Benefit Act, Council will be addressing that in further arguments, Your Lordships. Your Lordships, the third consideration to be made is that of her termination being a clear case of simple termination. As council stated, in the case of Pavendra Narayan Verma versus Sanjay Gandhi PG of Medical Sciences, there was a clear distinction between simple and stigmatic termination, as has been stated by the council. Your Lordship, the fact that the petitioner was found to be unsuitable is up to the discretion of the employer, as held by the Delhi High Court in the DTC versus Premnath case. And Your Lordship, the termination was carried out.
Council, what if we were to, you are now trying to convince us that because you don't want to give her the benefits of Maternity Act, you are now trying to convince us that she is not suitable for the job and she is not competent.
Yes.
Is that the
Indeed
notion
not,
of the
Your Lordship.
company, that you want to deny her maternity benefits? She is a sole breadwinner. She has lost her husband. And at this point of time during COVID, you just want to deny her. So we also have a humanitarian ground to look into the matter. It is a question of employees. So now you're pushing us to conclude that the company is afraid of taking care of her maternity benefits.
Indeed, Your Lordships. Your Lordships, addressing the Maternity Benefit Act, firstly, speaking of the respondent's liability according to section 12 subsection 2 subsection A of the maternity benefit, which states that if but for her dismissal she would be eligible for maternity benefits regardless of such maternity benefits. Regardless of such termination, she would be eligible to maternity benefits. Your Lordship is humbly submitted by the council that her employment as a probationer in due course was not guaranteed. An assumption cannot be reasonably made that she would go on to serve 80 days without being found suitable for the job role. This is to say that but for her dismissal, she may have been eligible for maternity, Your Lordships, if she wouldn't have been terminated for being found unsuitable or her work being found unsatisfactory before the 80-day proviso given in section 5 subsection 2. Your Lordships,
Council, your time is running out, if I'm not wrong.
much obliged, Your Lordships. Your Lordships, addressing the fact that touching again on the fact that Progressive Education Society versus Rajendra, the Apex Court of India held that unless there is unless the probationer is found to being called upon to show cause, there need not be they need not give any explanation other than to inform them that their services are being terminated. And fourthly and finally, Your Lordship, the last consideration in the respondent's argument is that there are no questions of gender discrimination
Council,
arising.
that's a case where an inquiry was held, Council.
Much obliged, Your Lordship, but Your Lordship,
Latter.
Your Lordships, and this was an observation given that the reason for why the inquiry was held was because there was a show cause notice, Your Lordship.
Yes, in this it is different. That is what we are trying to tell you.
Much obliged, Your
On
Lordship.
facts, that was a case where there was an. Okay, I think your time is over. And court manager, I think you're giving the same time the other either team, right, to the other team moves.
Yes, sir.
Okay.
Much obliged, Your Lordship. Your
Thank you.
Lordship, in the interest of justice, counsel asked for an extension of 2.5 minutes.
No, we have given now. Again, then it will kind of affect the whole system.
Oh, much obliged, Your Lordship. Is this a continuation to the 5-minute extension that was given to counsel one of the opposing counsel?
So are you
Sir,
more 5 minutes for
No,
your
Your
argument?
Lordship. Your Lordship, I was unaware of the 5-minute extension I was getting. Much obliged, Your Lordship.
Court
Your
manager, how
Lordship,
much more does Speaker 1 have, court manager?
Sir, he can have 3 minutes more extension. We have provided 2 minutes extension to him. And as per the protocol, we have to show the time over after 2 minutes.
much obliged.
As he is asking for 2.5 minutes right now, if you permit, then the time over slot will be shown after 2.5 minutes.
But then the other counsel will have only 30 seconds extra. So he wants 4.5 minutes of the extra, in
Yes,
other
sir.
words.
Yes, sir.
Okay, fine. Yeah, fine.
Much obliged, Your
You
Lordship.
can, so make it 4 minutes and 1 minute to the other counsel, so that this
Sure,
half
sir.
a minute doesn't.
Much obliged, Your Lordship.
Thank
Your
you so
Lordship,
much.
counsel will try to be brief so that the balance of the time can be given to my learned co-counsel.
You put your best foot, counsel.
Much obliged, Your Lordship. Your Lordship, fourthly and finally, the last consideration in the respondent's argument is that there are no questions of gender discrimination arising out of the respondent's conduct. Your Lordship, the respondent took a gender-neutral approach as the unavailability of material time was the bone of contention between the respondent and petitioner, not vendetta-fueled gender discrimination. Even though there are material differences between men and women going through a medical procedure, the result of both is same. That result, namely being unavailability from work, which would lead to the termination of service of anyone in that situation.
See, the facts of the case make us presume that the nature of work is something which can be done by women. If you are talking about gender discrimination, otherwise you would have, otherwise the company would have preferred a man any other day. So when you are aware that, fully aware that the nature of work deserves a woman to occupy that seat, then you should also be prepared to meet all the consequences of meeting all the benefits.
Your Lordship,
this is an absolute case of gender discrimination.
Your Lordship, counsel would like to point out that the respondent believes that there is no concept like a man's job and a woman's job. The respondent believes that any job can be done by a woman. We're just trying to point out that, as stated by the counsel, that
then you should have hired a male. See, when you fully know that you're hiring somebody else in view or in replacement of a maternity of an employee, then you should have hired a male if you feel that this can be done by either of the gender. My learned brother has another question for you. Sir, please. Shukumar, sir, please.
Let them proceed.
Your Lordship, in conjunction to the first query, which was about the work from home provisions, it is humbly brought to the attention of the learned bench that work from home provisions are at the discretion of the employer and if the work profile allows for them. Your Lordships, the factual matrix remains completely silent on the nature of the, Your Lordship, an extension of 30 seconds to finish the arguments.
No, that will be at the cost of your co-counsel.
Much obliged, Your Lordship. Your Lordship, the council humbly likes to point to the fact that work from home is up to the discretion, and it would have been granted to Ms. Rakhi herself if the job role was such that we could have provided for that. And also, Your Lordship, that
Thank you, counsel. Thank you, counsel. Thank you. This is not, we have to balance both the teams. Please.
Much obliged, Your Lordship. Fourth, Your Lordships, in conclusion, the council would like to say that taking all four main consideration of the respondent's argument into account, it is clear that the respondent was not at odds with the standing orders governing the termination of services of a female employee.
Thank you, counsel. Thank you. This is we have heard you enough. Thank you so much.
Much obliged, Your Lordships. I now call upon my learned co-counsel to address the second contention. Thank you, Your Lordships. It's been a pleasure arguing before this honorable bench.
So she will have 1 minute extra, right, court manager?
Sir, 30 seconds.
30 seconds. Okay, fine. No, whatever. Because you are the right person for it. 30 seconds. So I guess they are also aware of it now. Yes.
Yes, sir.
Good greetings, Your Lordship. This is Counsel 2, Pratyaksha speaking on behalf of the respondent. May the counsel begin with her argument.
Please, counsel.
Much obliged. Your Lordship, the counsel shall be dealing with the second contention and shall try to prove in the course of her argument that the dismissal of Ms. Kangna does not violate any human rights under the Constitution and the other human rights treaties and conventions signed and ratified by ADGAR. The counsel shall be dealing with the contention in three legs. Firstly, by drawing the attention of the court to the fact that the respondent is a private entity. Secondly, by establishing that the dismissal of the petitioner was neither unfair nor illegal. And thirdly, by drawing the attention of the court to the economic considerations that are relevant in the present case. Now, Your Lordship, beginning with the first leg of the arguments, Your Lordship, the respondent in the present case is a private entity. Your Lordship, the counsel has drawn the attention of the court to this fact since the specific rights that the petitioner is claiming that the respondent has violated are the rights which are not applicable against the respondent. Your Lordship, as we know, that it has been traditionally held by the judiciary that only state actors or its instrumentalities can be held liable for the violation of fundamental rights given in Part 3 of the Constitution. The courts have mainly relied on Article 12 of the Constitution to draw the said conclusion. Your Lordship, however, there are still certain fundamental rights that have horizontal applicability, such as Articles 15 Clause 2, 15 Clause 5, 17, 23, and 24 of the Constitution, which are still directly enforceable against private individuals or bodies. Your Lordship, the counsel submits that since there has been no violation of the rights provided under these aforementioned articles, it can thereby be said that no fundamental rights of the petitioner have been violated. Your Lordship, the Council would like to rely on the case of A.K. Gopalan versus State of Madras, in which the apex court had held, and I quote, as for protection against individuals, it is a misconception to think that constitutional safeguards are directed against individuals. Constitutional safeguards are, as a rule, directed against the state and its organs, and the protection against violation of these rights of the rights by individuals must be sought in the ordinary law. Therefore, Your Lordship, the apex court through this landmark case had completely negated all the possibilities of applying fundamental rights against private individuals. Now, Your Lordship, coming to the second leg of the argument that the dismissal of the petitioner was neither unfair nor illegal. Your Lordship, the petitioner in the present case was an employee on probation for a period of 1 year, and therefore it is humbly submitted that her termination from employment was lawful as it was on account of her unsuitability for the job. Your Lordship, my co-counsel has already established this argument, and the council shall be drawing the attention of this honorable court to the fact that the suitability of the petitioner as a probationer was to be judged on the sole basis of how well she would have been able to fulfill her duty to act as Ms. Rakhi's replacement in the company. Your Lordship, reliance is made to para 9 of the factual matrix, which states that the documents before the industrial tribunal state that the employers had shown that the reasonable needs of their business required that the person recruited to cover for Ms. Rakhi during her paternity leave be available throughout the time. However, Your Lordship, since her ability to perform as a replacement was compromised due to her unavailability to be at work during the precise time that she would have been required, thus this made her instantly unsuitable for the job, and it is therefore humbly submitted before this honorable court that the cause for rendering her unsuitable for the job must be deemed to be irrelevant. Your Lordships, it is humbly submitted that the availability to be at the job during the period specified was the inherent requirement of the job, and the inability of the petitioner to fulfill the said business requirements of the employer is the sole reason for her dismissal. Thereby, Your Lordship, the termination of employment of the petitioner is not in contravention of any of the rights of the petitioner. Your Lordship, to state an example, Your Lordship, now the Council would like to come to the third leg of the arguments relating to the economic considerations that are relevant in the present case. Your Lordship, it is humbly submitted before this honorable court that the respondent had taken into account perfectly rational and commercially understandable considerations which were neither trivial nor insubstantial in nature while terminating the services of the petitioner, and thereby had performed no such action which was outrightly unfair. As established earlier, the petitioner's pregnancy was not the cause or prerequisite for her dismissal. Your Lordship's reliance in this regard is made to a case of South Africa, where common law is prevalent, and as can be observed from para 2 of the factual matrix, that the decisions of major countries where common law is prevalent are of significant value to the Republic of Asgard. Your Lordship, in the Woolworths case, the learned judge J.A. Willis was of the view that the profitability of an employer's business and the pregnancy of a prospective employee are perfectly rational and commercially understandable considerations. Your Lordship, the learned judge in this case had opined that the evaluation of what is fair and or unfair in the workplace must be conducted with an eye of economic reality. Your Lordship, the findings of the aforementioned case are of view.
So, Council, I'm sorry, I was on mute. I was just asking you kindly come to paragraph 3 of your facts of the case, Council.
Much obliged, Your Lordship. Yes, Your Lordship.
What is the name of the company?
Antariksh Logistics Limited, Your Lordship.
No, read the complete. What's in the
Antariksh
bracket?
Logistics Asgard Limited.
Yes. So, is there not an indication that it is a government undertaking or a public sector?
Your
Your
Lordship,
argument is that it is a private company, it is a private sector. So, does not the
yes, Your
facts
Lordship.
indicate? So, then what do you have to say about Article 5?
Your Lordship, the company is a private entity since it is not government owned or government controlled. Your Lordship, as it can be observed from the fact that the laws in Asgard are pari-material to the laws in India, and as we know that in India, the only logistics company which is government owned or government controlled is the India Post. All other companies that are operating in India are privately owned or are private entities, Your Lordship. Therefore, since the company's name itself suggests that it is a public limited company, which means that it can public limited companies are basically those which can trade its shares in the stock market, making it owned by the shareholders. And all these public limited companies are indeed a part of the private sector, Your Lordship.
No. What we are
Therefore,
asking is your submission. The basis of your submission is that the right under Article 12 does not accrue to the appellant here or the petitioner because you are not under state, because the company is not a establishment under which a violation of fundamental right can be prayed against.
indeed.
Correct. So we're just putting forth to you that the name indicates that it is a government undertaking or a public sector company. So you have done a lot of research. So please let us know that if it were to be a public undertaking, a government undertaking or a public sector company, then would a right under Article 12 accrue to the petitioner before us?
Your Lordship, there are many companies which have for example, taking the case of India, there are also many companies which attach the name India in brackets before stating limited in it. However, that doesn't make them a company which is government owned or which is a functionary of the state. Similarly, in the present case, the council submits that it is a material fact, it is a fact of substantial nature if it would have been a public sector undertaking. However, Your Lordship, in the case, it can be clearly observed that it is a private entity since looking at the scene of India, that only India Post is the only logistics company which is government owned or state controlled, Your Lordship. And in the present case, Antariksh Logistics is a private entity, Your Lordship.
शादी
Please
हाँ तो
proceed.
आगे आते हैं
Indeed, Your Lordship. Your Lordship, as can be observed from para 2 of the factual matrix, that the decisions of major countries where common law is prevalent are of significant importance to Republic of Asgard. Therefore, Your Lordship, the Council has laid down the case of Woolworth versus Whitehead, in which the learned judge J.A. Willis was of the view that the profitability of the employer's business and the pregnancy of a prospective employee are perfectly rational and commercially understandable considerations. Your Lordship, the learned judge in this case had opined that the evaluation of what is fair or unfair in the workplace must be conducted with an eye of economic reality. Your Lordship, the findings of the aforementioned case are of due importance in the present matter, considering the fact that Asgard is a developing country in South Asia. And since, Your Lordship, Asgard is a developing economy, it would not have the same levels of affluence, the low birth rates, and the same highly developed insurance system that inter alia make decisions such as that given by the European Court of Justice in the Webb case and in the Decker case, easily absorbable in the social fabric that exists in Europe. Your Lordship, the judge in the aforementioned case had also stated that it would be inappropriate for the court to deliver a judgment as though it were cocooned in the intellectual and moral parameters of a rich first world country. It is thus humbly submitted before this honorable court that if courts were to make their decisions entirely indifferent to profitability, the consequences for our society would be disastrous. Thereby, Your Lordships, employers basing their commercial decisions on reasonable probabilities and risk taking, which is intrinsic to enterprise, should not be viewed as being malified. Your Lordships, the Council humbly pleads before this honorable court that in the aforementioned case, emphasis was also laid on bona fide business reasons or bona fide commercial rationale of the employers. Your Lordship, the court had held that in order to suffice as a defense, commercial rationale must be of a sufficient magnitude and that it should be akin to business necessity. Your Lordship, as can be observed from the present case, that the employer had acted solely out of business necessity. Your Lordship, the Council would also like to draw the attention of the Honorable Court to the fact that that in the Webb's case, which is highly similar to the present matter, The European court had failed to consider the situation where a woman, on account of her pregnancy, would not be able to carry out at the time when her services are required the particular job for which she is applying or for which she has been engaged. Your Lordship, the opposing learned counsel had mentioned the same case, that is the Webb versus EMO air cargo case. However, Your Lordship, the counsel would like to attract the attention of the court to the fact that the appellant in the Webb case was appointed for an indefinite period, contrary to what has happened in the present case, where the petitioner is on probation. Therefore, Your Lordship, the European Court in this case had also failed to give any clear indication whether in such a situation the court would have given more importance to the fundamental reason.
Counsel, very appropriately, like you were telling that she was in probation. Now they have raised a ground before us. They have relied on the case of Municipal Corporation of Delhi versus Female Workers Muster Roll, which is very clear that even daily wages and others under probation, because this act is more of a social welfare legislation. So if you concede, let me just complete. So if you concede even on the question of probation, see, as on today, it's an admitted fact that she has been employed by your company. But the dispute is whether she is on probation or whether you had to regularize her, etc. How do you differentiate yourself, or how do you convince us that you are not bound by the decision of this Honorable Court in Municipal Corporation of Delhi versus Female Workers?
In the Muster Roll case, the contractual employees, as the council remembers, had been working for 3 years or more in the same enterprise, and they were subsequently not given maternity relief solely on the ground of them being contractual employees. However, in the present case, Your Lordship, the petitioner has not served even for not even 30 days, and the respondent in the present case reserves the right to dismiss her on the ground of her unsuitability, Your Lordship.
Proceed.
Will the council proceed with the argument?
Please proceed.
Yes.
Go ahead with Mr. Roll.
Continue. Please continue.
Your Lordship, the European Court in the Webb versus EMO air cargo case had failed to give any clear indication whether in such a situation the court in such a situation where a pregnant employee would not be able to fulfill the sole objective for which she had been employed, the court had failed to give any indication in which the court would have given more importance to the fundamental reason for dismissing her as being her unavailability for the job and not her pregnancy. However, Your Lordship, it is humbly pleaded by the council that the imperatives of an employer to operate an efficient and cost-effective business or organization, as well as business considerations and profitability, must be equally weighed against the employee's basic rights. Your Lordship, the council would like to draw the attention of the court to the fact that the employer in the present case does not have any kind of irrational antipathy towards pregnant women employees, given the fact that the employer has a policy of giving female employees paid maternity leave. Your Lordship, also the council would also like to refer to the case of State of Punjab versus Sukhwinder Singh, in which the Supreme Court had held that the superior authorities in a department have to take work from an employee, and therefore they are the best people to judge whether an employee should be continued in service, having regard to his or her overall suitability for the job. Now, Your Lordship, however, the council would like to draw the attention of the court to the peculiarity of the case, that is, the inherent requirement of the job necessitating the employee to be at work during the period of absence from work of another permanent employee. However, Your Lordship, since her ability to perform as a replacement was compromised due to her unavailability to be at work during the precise time that she would have been required, thus this has made her instantly unsuitable for the role, Your Lordship. Lordship, the council would like to move to the prayer if your Lordship do not have any further questions.
You still have 5 minutes. Do you want to convince us on anything else that we were asking your co-counsel about?
Your Lordship, the council would mainly like to state that the dismissal of Ms. Kangana was solely on ground of her unsuitability for the job and nothing else. Your Lordship, the Council would like to rely on the case of Purushottam Lal Dhingra versus Union of India, in which the Honorable Apex Court had held that on employment on probation would come to an end if during the probation period the servant so appointed on trial is found unsuitable. Your Lordships, in
So,
this case, it was also held that in the case of appointment of a person on probation, the person so appointed does not acquire any substantive right to the post and consequently cannot complain if his or her service is terminated at any time. Thus, Your Lordship, services of an employee on probation would be terminated when he or she is found unsuitable for the job for which he or she has been engaged. Your Lordship, also in the case of P.C. Pillai versus IIT Madras, the Supreme Court had held that the suitability does not depend merely on excellency or proficiency in work. There are many other factors which enter into consideration in order to confirm a person on probation. Therefore, Your Lordship, Council would merely state that the petitioner has not been unfairly discriminated against and the dismissal is not unlawful or in contravention of any of the rights of the petitioner in this case, Your Lordship.
let me know. You have argued in your case. You have dismissed to Ms. Kangna on the ground of suitability or inability. And then the process of natural justice, why you have not followed?
Your Lordship,
The
in
opportunity of
many
hearing
in
should not be, you have not given to the Ms. Kangna. The opportunity
uh,
should be given. If the sole matter is whether the case is related to the suitability or inability, not a ground of on the ground of pregnancy.
basically in a plethora of judgments, the courts uh, uh, have opined that a probationer does not have the right to be given a suitable opportunity to be heard in the cases where the termination does not cause a stigma to the probationer in the case of their dismissal, Your Lordship. Therefore, it is
So
not.
what was the inability to do work? What you
Your
have
Lordship,
find?
in the present
What was
case,
the inability? Why
in the
why she was not fit for the job?
Your Lordship, in this present case, petitioner was employed for the sole purpose of performing the job of another employee while she would have been absent for maternity leave. However, in the present case, we can see that both their maternity leaves would be overlapping, which would lead them to be absent at the same time, which would
How
have
you can
initiated.
imagine कि she will also claim for the maternity leave if she is not claimed in her any petitions or in arguments.
Your Lordship, that is a
Even
reasonable
in
assumption that
prayer,
that if she's.
there is no any request to for the benefit of maternity claim or
Your
maternity
Lordship,
leaves
it
or
is a
maternity
reasonable
benefits.
assumption that 6 weeks, as in given in the Maternity Benefit Act, that 6 weeks before the
That is another thing. That is another thing. But you have dismissed to Ms. Kangna on the ground of inability because she was on probation. The probation can be extended or in the contractual matters. In the contractual matters, if you have find any the inability, what was the ground?
Your Lordship, the council would
Have you
still
given any
instate
notice?
upon.
Have you given any warning? Ki you are doing not well. You are not doing a proper work. You are not
Your Lordship,
fit for this job.
Your Lordship, the council would like to rely uh, on the case of Krishna Devaraya Education Trust versus L.A. Balakrishna, in which it was held that the services of an employee on probation would be terminated when he is found not to be suitable for the job for which he is engaged. Moreover, the power to put the employee on probation for watching his performance and the period during which the performance is to be observed is the sole prerogative of the
Of course,
employer.
during the probation period, you're watching the performance and efficiency of the employee. So have you watched anyway?
Your Lordship, the council is relying on the case of Ajit Singh versus State of Punjab, in which the court had held that it is the sole
Okay,
prerogative of the employer
council,
to decide.
just one last thing. Your time is also sitting on. So, in view of Section 27, this is a legislation that has to be balanced for us it is more in favor of protecting women and their pregnancy. So if we were to lay down a law today on these facts of the case, it should be in favor of the pregnant women. What do you have to say?
Your Lordship, the Council has tried to rely on the relevant economic considerations in the present case and has tried to establish that the employer had solely acted out of business necessity and business requirements. Your Lordship, the dismissal in the present case was solely on ground that it was wholly unrelated to the pregnancy of the woman, and it was only on ground of her inability to perform this sole task that she was employed for. Her pregnancy does not play a role in it. Just her inability to perform the sole task that she was employed for is the reason for her dismissal, Your Lordship.
Thank you.
Your Lordship, may the Council proceed with the prayer.
Yes, please.
In the light of the facts of the case, issues raised, arguments advanced, and authorities cited, the Council, on behalf of the respondent, humbly pray before the
Council,
Honorable
should we
Supreme Court of
listen to your prayer or just dismiss the petition?
Yeah.
Your
You
Lordship,
want us
in
to
the
listen to your prayer or
We
dismiss
pray
the
only
petition? You
for
please
this.
tell us.
conscience, the Council
Sorry?
pleads, in the best interest of justice, equity, and good conscience, the Council pleads if the court may allow the Council to plead the prayer before it. Please.
We are asking a simple question. We have seen your prayer before us in the memorial. We are just asking a simple question. Should we give you all the relief in the prayer, or shall we simply say the petitioner's case is dismissed on lack of merits?
Your Lordship, what the Honorable Court would deem fit in the best interest of justice, equity,
No,
and good
we will give what you pray for. We are here to grant you relief. So what is your prayer finally?
Appeal should be
Lordship,
allowed or it should be dismissed?
It should be. It should be. The prayer should be allowed, Your Lordship.
Fine.
You are on behalf of respondent.
Thank you,
You
Counsel.
are on behalf of respondent. So what is your conclusion of argument? Would you like to appeal should be allowed?
Oh, the appeal should not be allowed, Your Lordship.
Okay,
The
okay,
Council
that's all.
misheard, misinterpreted the court.
Thank you.
May the
Thank you,
Council.
Counsel. Your time is over. Already we have given extension.
The
Court
Council
manager.
shall conclude with the prayer.
Yes. Again, you want to pray? We just.
Okay.
Thank you,
All
Counsel.
right. Thank you, Your Lordship. It was an honor arguing before this honorable court.
Thank you all of you. Counsel, I'm sorry, court manager, I think 1 minute extra दिया था ना? That means we had given 1 minute extra.
Yes, sir, we have given that.
Yeah, kindly manage that now. This
Yes,
extra 1 minute we gave to speaker too. Please manage that in the rebuttal so that the time is same.
Yes, sir. Sure, sir.
So this 1 minute only to the other team.
Yes, sir, for rebuttal.
Only to the other team. Thank you.
Please, Your Lordships. If Your Lordships allow, then I may please be permitted to start the rebuttals now.
1 minute. Court manager, do they have a sir rebuttal?
Sir,
After rebuttal, do they have a sir rebuttal?
it's upon the discretion of judges, if you may allow it, maybe.
How many minutes is the rebuttal?
So they have asked for 3 minutes for sir rebuttal.
Plus 1 we have granted now.
They have asked for 5 minutes for rebuttal, sir, and plus 1 you have granted now.
So 6 minutes they have.
Yes, sir.
Totally. So I would request that you give at least 2 minutes for the sir rebuttal, no? Because 6 minutes of rebuttal and without a sir rebuttal may not complete. So give at least 2 minutes for sir rebuttal.
Sure, sir. Sure.
2 or 3 minutes, huh? We'll just.
Sure, sir.
I am sure the others will also agree with me. Sir, it's fine, no, sir?
Yeah.
Let's be fair. Hearing should be balanced both sides. Yeah, please, counsel, please. 6 minutes for you.
Please, Your Lordships. Lords, protection has been sought by the respondent under Article 12, claiming that they are private entities. Lords, I'll read out the relevant para of the judgment of this Honorable Court in Federal Bank Limited versus Saga Thomas. Lords, wherein it says, such private companies would not normally be amenable to the writ jurisdiction of the court, but in circumstances a writ can be issued to such private bodies or persons as there may be special statutes which needs to be complied with all concerned, including the private companies. Lords, the court gives examples. For example, there are certain legislations like the Industrial Dispute Act, the Minimum Wages Act, the Factories Act, or for the proper maintenance of the environment, or the statutes of like nature will fasten certain duties and responsibilities statutorily upon such private bodies which they are bound to comply with. Your Lordship, my case aligns with this matter. My Lords, it is my simple case that is a violation of the principles of natural
What is the
justice.
citation? Citation?
Your Lordships, within a moment. Your Lordships, this is Civil Appeal number 106 of 2001, Federal Bank Limited versus Sagar Thomas and others.
Reported?
I'll check, my Lords, within a moment.
It is okay. You don't have to exhaust your time. You can go ahead.
Yeah.
Your Lordship, this had been reported in the All India reporters.
Yes, please.
Your
Which year is
Lordship,
this?
my Lords, it is of the year 2003, my Lords.
2003. Okay.
My Lords.
What is the name of the party? Is it all Federal?
Federal Bank Limited versus Sagar Thomas and others, Your Lordships.
Okay, yeah, please go ahead.
Your Lordships, the other relevant para also says that the principles which emerges from the above judgments is that a writ petition would be maintainable against such and such parties. Your Lordships, 1, 2, 3, 4, it goes on till 7. Your Lordship, 7th is a person or a body under liability to discharge any function under any special statute in order to compel it to perform such a statutory function. Your Lordships, it is my present case that Section 12 of the Maternity Benefits Act is being violated, and that is the statutory authority I am relying upon, Your Lordship. In order to compel the respondents to reinstate me with back wages, Your Lordships, the impugned order being in the mandate, in the teeth of the mandate of Section 12, Your Lordships, that the present petition can be entertained and is maintainable, Your Lordships. Furthermore, my Lords, the aspect of web versus MO cargo has been argued. It has been argued, my Lords, by my learned friends to the effect that in such a matter, my Lords, in the case of web versus MO cargo, the petitioner was not a probationer, Your Lordship. Whereas to the contrary, my Lords, if I present the facts, the petitioner in that case, my Lords, had joined on 1st of July 1987. A similar order, as is in the present case, my Lords, was impugned, my Lords, and the petitioner was terminated on 30th of July 1987. My Lords, making 30 days, as is in the present case, my Lords, having perimeter to the facts of the present matter. Your Lordship, further, my learned friends have tried to equate unsuitability with pregnancy, Your Lordship. With the kind permission of the Honorable Court, I seek to disagree from that opinion, my Lords, for the simple reason that unsuitability is a misnomer which cannot be attached to my pregnancy, Your Lordship. As I had already argued in my submissions, Your Lordships, I can still be of avail to the respondent company. The business needs can be very well managed if I am giving a reasonable accommodation. The principles of reasonable accommodation is intrinsic in the constitution itself, Your Lordships. Until or unless the respondent company is able to show adherence to the principles of natural justice, adherence to Section 12 of the Maternity Benefits Act, further, my Lords, the tests which have been prescribed under Article 14 that they cannot claim such a protection, Your Lordships. Furthermore, my Lords, the court in judicial review while examining such judicial orders, Your Lordship, is more concerned with the decision-making process. Your Lordship, please see how the impugned order came to be passed. Your Lordship, the indirect information comes to the employee. They call me and they indicate particularly that I would be terminated from my services. Your Lordship, this in itself...
Counsel, just one question because your time is wrapping up. See, in muster roll case, they have rightly pointed out that the employee had to be employed at least for 3 years minimum. That is there in paragraph 29. So you have to differentiate that. And secondly, this is not a case like they rightly said that you have informed that you were pregnant. It is a case where they came to know that you were pregnant and then they immediately took action and hence there is no natural justice applicable. Please address us just on these two issues. You have 2 minutes.
My Lords, 2 issues. Firstly, my Lords, the muster roll case, my Lords, that is the qualification for claiming the payment of maternity benefit. My Lords, that is a case wherein the muster roll employees claimed that we should be given the payment of maternity benefit under 5 brackets 1, my Lords. My Lords, 5 cross 2 says that in order to claim maternity benefit, you need to have 80 days of qualifying service. It was for this purpose, my Lords, that this Honorable Supreme Court said that since the 80 days qualification is met, that the eligibility for payment of the maternity benefit is met out. As my Lordships, we have categorically stated in our arguments that we are not claiming the payment of maternity benefit, but the protection of Section 12. Your Lordship, the eligibility of 80 days comes in play only when we claim we give a notice under section 6 claiming the rights under section 5 brackets 1, your lordship, and not otherwise in section 12. Your lordship, further, to give the information to the appellant is required, my lords, when I bona fidely contend that the payment of maternity benefit should be given to me. That is, my lords, the legal requirement under section 6 of the Act. My lords, but that is not the case here. Your lordships, to wrap up and to conclude, I would just present a data before your lordships. The ILO data says India females labor force participation rate in 2021 was lower than the world average at 25.1%. Your lordships, it is in these facts and circumstances that I, being an appellant and a childbearing woman, my lords, a single bread earner with no husband, in such a pandemic cannot be left at the discretion of, I cannot be left at the perils, my lords. I am on my foot before this honorable court. The termination, my lords, of the appellant in such circumstances is not only callous, but a cruel act and an open insult to womanhood, my lords, in India, which is the most sacrosanct and cherished institution. With that said, my lords, I believe that the judgment of this honorable court shall be in the best interest of justice and shall be serving as a binding force upon all the courts. With that said, my lords, I bow.
Thank you, Counsel. Counsel, you note that citation, it's 2003, 10 SCC 733. 2003, 10 SCC,
My lords.
2003, volume 10 SCC 733. That is Federal Bank versus Sagar Thoms.
I'm highly obliged for your suggestions, your lordships. It was indeed an hour.
No, just note it down now that you have told us. Thank you. Thank you.
Your Lordship, Council 1 asks for the Honorable, your Lordship's permission to begin with the sir rebuttals.
Please, sir.
Much obliged, Your Lordship. Your Lordships, as held by the case of Mahavir Singh versus Delhi Transport Corporation, to be heard will not be imperative while terminating the services of a probationer. Your Lordships, secondly, the factual matrix remains absolutely silent on the nature of her roles in the role in the import departments, Your Lordships. The only thing that has been mentioned is that she works in the import operations department, and the second thing we know is that the respondent was not able to provide work from home benefit, that is a discretionary right of the respondent, to Miss Rakhi, the original employee who was bound to go on maternity leave, Your Lordship. Your Lordship, in the case of Godrej and Boyce, Godrej and Voice Manufacturing Company versus Madras, the Honorable High Court of Madras has said that has held that setting aside dismissal on the grounds that it will be hard to find employment is not justified, Your Lordship. And finally, the council contends that, Your Lordship, protection under Section 12 can't be taken as the respondent can't be reasonably made to assume that there would be no findings of unsuitability through the probation period of the petitioner, as the entire point or the entire reason for the exercise of putting the petitioner through a probation was to test her suitability. And finally, Your Lordships, the
Counsel, we have
federal
one
right-
question, Counsel.
Much
Have you
obliged, Your
dismissed
Lordship.
her on the ground of not suitability? What you on the basis of competence or insuitability, or on the basis of a pregnancy?
Your Lordship, on the basis of unsuitability.
Then again, we would ask, why does your order of dismissal say about pregnancy?
Your Lordship,
So,
as
We
contended,
missed you in the last time. Your time got over. Now that
much
you're back,
obliged, Your
please.
Lordship. Your Lordship, as contended by the respondent previously when asked the same query, it was communicated, the reason for her unsuitability was communicated to her out of good faith of the respondent, Your Lordship. And Your Lordship, in future references or termination orders, respondent will make it a point to have even more clear and cogent termination orders, not leaving anything to the imagination or
Okay, thank you.
implication.
Your time is over. Thank
Much
you.
obliged, Your Lordships. It's been a pleasure arguing before this honorable court.
Thank you. It's a pleasure for us also to hear all of you. Excellent.
yeah, same here.
What next, court manager?
Hmm.
Now, if the judges permit, we would like to take a screenshot of the courtroom for social media platform. If you permit, sir.
Yeah.
Okay.
Yes, yes.
Okay. So
And
I'll
there is
request
live
everyone.
streaming already. I don't think you have to ask us again.
I'll request everyone to kindly switch on your cameras. Thank you, sir. Now the students may leave the, I will ask the judges to kindly give the scores. Good afternoon, sir. Here, I am very feel honored and privileged to welcome on our chief guest, Honorable Mr. Justice Virendra Kumar, Judge, Rajasthan High Court, Jaipur Bench. I, Nisha Gandhi, Student Convener, Moot Court Committee, welcome you, sir, on behalf of Moot Court Committee and Raffles University, sir. I request the judges to kindly do the scorings for this round.
We have to mail it back as an attachment?
No, sir. The moment you will enter there, we'll automatically get your scores.
Okay, it's live. Okay. Thank you.
Thank you, sir.
Excuse me, ma'am. Do you want the participants to leave the meeting in order to provide some privacy to the judges?
Can you give us I would suggest the court manager if you can give us a breakup session of the same screen again, no?
Yes,
We
sure,
can also
sir.
see the students once and then the judges can have a breakup. About 2 minutes, we can also see the students once.
I'll request the students to leave this meeting. We will send you a message to rejoin it.
Right, ma'am. Thank you so much.
Thank
No,
you.
I was just requesting you for a breakup with the with the same screen. Is it possible? With the same session?
Yes, sir, it is possible.
Yeah, just give us for 2 minutes, no? We just wanted to.
Sure, sir. Sure, sir. We are allotting you, sir. Just a minute, sir.
Yeah.
Good afternoon, sir. Virendra, sir. I request Your Honor to kindly wait for the judges to score for the final rounds.
Thank you.
I'll request the judges to kindly accept the breakout sessions invite so that you all can go into it. And I'll request Honorable your Lord to kindly wait. We are just starting the valedictory ceremony once the judges are done with the scoring.
Excuse me. Uh, Court manager, please.
Hello. Yes, sir.
Yes. Let me find the balance sheet.
Sir, we have just mailed you, sir.
Okay.
Yes, sir. You will get that in the mailbox, and if you're not able to see it, sir, we will reshare it.
Resend it, please.
And sir, kindly accept the judges' breakout sessions invite, so can you will be there.
Okay.
Okay, sir.
Courtmaster, I have submitted my result. Please check it out. It is available to you or not? Aditya Tomar.
Sir, we have received, sir. Just a minute, sir. Aditya sir, we request you to kindly accept the breakout sessions invite so that you can be added to the breakout session.
Okay. In a mailbox?
No, sir, you will be received on the same screen, sir, WebEx screen. We are just resending it, sir.
Okay.
And Shiv, sir, you also kindly do that.
Yes, please.
Good afternoon, everyone. We are about to start the valedictory session, so kindly switch on your mics and kindly switch on your cameras.
With due respect, we would like to commence the valedictory ceremony of 5th Surana and Surana School of Law, Raffles University, National Labour Law, Moot Court cum Judgment Competition.
तदेजति तनेजति तदूरे तदंतिके तदस्य सर्वयस्य तदु सर्वयास्य भ्रात. Truth is God, and all virtues follow the truth. All are rooted in truth, and there is nothing higher than the truth. Today is a big day to think of how far flung we have come and how far we have to go. Along with the multifarious struggles and triumphs, there is much more to thrive and much more to show.
Rejoice in the majestic journey this establishment has had up to now. Let's raise a toast to make it even better. Let us now take a walk. Good afternoon. Here are Honorable Chairperson, well-acclaimed Chief Guest, Guest of Honor, all treasured invitees, revered teachers, and of course, all starting students.
We all are here for the valedictory ceremony of 5th Surana and School of Law, Raffles University, National Labour Law, Moot Court cum Judgment Writing Competition 2022, and add another milestone to the accomplishments of our esteemed institute, Raffles University. So I, Yukti Bharadwaj,
and I, Ayushka Sharma,
welcome you all on behalf of entire Raffles family.
it is a mark, I quote, be inspired, broaden your horizon, aim for excellence, and achieve all your dreams, I unquote. We, the student of Raffles University, study here with the mottos and values given by late Mr. Vinod Kumar Gumbar sir.
We feel honored and privileged that a leading law firm like Surana and Surana International Attorneys has hosted, administered, and sponsored over 100 moot court competitions with India's leading law schools. The project is one of India's largest, oldest, and most prestigious moot court competitions. It is a mark of our undying tradition to invoke the Almighty God at the beginning of an important event. So let us start the event with the virtual lighting of lamp.
कुन्देन्दु तुषारहारिता
With such a beautiful note to start with, I would like to call upon this forum our respected faculty co-convener Moot Court Committee, School of Law, Raffles University, Ms. Amit Kaur ma'am, for welcoming the gathering.
Thank you, Yukti. Thank you, Ayushika. It is a matter of immense pride for me to be here. I feel privileged to extend my warm welcome to all present here for the valedictory ceremony of 5th Surana and Surana National Labor Law Moot Court and Judgment Writing Competition 2022, organized by School of Law, Raffles University, in collaboration with Surana and Surana International Attorneys. I am honored to welcome our chief guest for the occasion, Honorable Mr. Justice Virendra Kumar, Judge, Rajasthan High Court, Jaipur Bench. Your Lordship, it is truly a matter of great pride that you have consented to be with us and have accepted our invitation to be the chief guest for today. I, on behalf of Raffles University School of Law, bow in your respect and welcome your Lordship. I am privileged and honored to welcome the patron, guiding spirit, guest of honor, Dr. Justice Meena V. Gombar, former Judge, Rajasthan High Court, Chairperson, Gombar Education Foundation. Madam has been a constant support system for organizing and mentoring this event. This event would have not been a triumph success without the august presence of Honorable Dr. Justice Meena V. Gombar. We thank you for that, ma'am. I feel overjoyed when I introduce you to our second guest of honor, our respected President, Professor Dr. Gadangi Indra, Madam. Madam, your presence has certainly brought limelight to this event. We thank you for your enlightenment. I also take this opportunity to welcome Advocate Preetham Surana, partner Surana and Surana International Attorney, and whole family of Surana and Surana. So we are really fortunate that you took your precious time out for this event and for giving young talented law students such an opportunity. The reason behind success of this moot court competition is only because of your efforts and your dedication. We are truly obliged by your corporation guidance throughout the event. I further humbly extend my gratitude to all the respected deans, Dean SOL, Dr. Osaf Ahmed Malik, sir, other dignitaries, and the participants present here. Before I conclude, I would like to thank the Moot Court Committee, Raffles University, and congratulate them for making this event a success with their tireless and effortless dedication. Thank you all. I hope you have a good evening. Over to you, Ayushika.
Thank you so much, ma'am. It would be impossible to imagine what we may have been today without the expert guidance of Honorable Dr. Justice Meena V. Gombar, ma'am, Chairperson, Gombar Education Foundation, a caring patron who has always been guiding light in our paths to excellence. With this, let's set about and call upon our respected ma'am to enlighten us with her words of wisdom. Over to you, ma'am.
Thank you, Yukti. Am I audible?
Yes, ma'am.
Yes, ma'am.
Okay. Thank you. Good afternoon, everyone. Hope everybody is doing fine and is healthy this morning. I had, as a chairperson of Gombar Education Foundation, the sponsoring body of Raffles University, Neemrana, I heartily welcome my younger brother, Judge Mr. Justice Virendra Kumar, Judge Rajasthan High Court, who has spared his Sunday afternoon rather, which is the purely a family time, to have agreed to be the chief guest virtually. I'm thankful to Mrs. Virendra Kumar as well, because I know the judges hardly get a time to have lunch together, except a Sunday lunch. Because Saturdays, though being off, we have to finish so much pending work, orders, corrections, etc., etc. On Saturday, the PA has to come and we have to clean up our then. So Sunday is the only time the family can sit together and have ease time. So thank you very much, Mrs. Kumar, for having allowed me to encroach on your family time by allowing your husband to be away for this long time. Thank you very much. Mr. Pritam Surana, Associate Surana and Surana International Attorneys, and Dr. Vinod Surana, who have been leading pioneers in the whole country as also abroad by organizing such prestigious competition throughout the year. We are lucky to have been associated with them for last 5 years, and this is the fifth Surana and Surana and Raffles School of Law, Labor Law Moot Court, National Moot Court competition, come judgment writing competition. Dr. Gadangi Indira, the President, Raffles University, Dr. Asaf Malik, Dean School of Law, faculty members, members of the organizing committee, my dear Rafflesians, and the dear participants who have been working hard for 3 days to the event culminates into the final results. First of all, I congratulate the organizers of the Moot Court for having organized the event successfully. The technology, we know when we depend, sometimes it may cheat us, but this has been a quite successful time that the technology supported you. My dear students, ladies and gentlemen, today is the last day of 3 days exercise of Surana and Surana and School of Law, Raffles University, National Labor Law Moot Court, Come Judgment Writing Competition 2022. And everyone here, I'm sure must be eager to know the results. However, as desired, and the other day I spoke about the subject on maternity benefit. And today I would like to briefly talk about the thought process behind the vision and mission as also a journey undertaken by Raffles Institution uh, under the umbrella edges of Gombar Education Foundation, the sponsoring body, established by my late husband Vinod Kumar Gombar. Life is a rare and a beautiful gift of God, and its fullness depends upon the inclination, the opportunity, and the ability of the person to touch as many points as possible during the course of its journey on this earth. While most remain content by walking on a chosen track, there are a few who choose the road less traveled. Raffles School of Law commenced its first session in 2011 and already 6 batches are out. The school, or for that matter, Gombar Education Foundation or Raffles University or the school, they all owe their existence to the vision of late Mr. Vinod Kumar Gombar, who translated into the trusteeship ideal of Mahatma Gandhi. It was his confidence in the youth of this country that impelled the establishment of this temple of learning. With his message to them, I quote, be inspired, which Yukti has already talked about. Be inspired, broaden your horizons, aim for excellence, and achieve all your dreams. Unquote. The young men and women present here virtually would do well to remember that men like Mr. Gombar, lead lives that spread an aura and fragrance which outlive their mortal sojourn on this earth. If one were to study what distinguishes such men and women from the multitude, two qualities will stand out. The first is their concern for the good of others, and the second is the constant striving for perfection and excellence with purity in personal and public life. Here, in Raffles School of Law, the ideals of our founder find expression in the Gurukula concept, whereby the students move away from the rough and tumble of a stressful existence to the quieter environment of the campus, which is at a detached location in Neemrana. This ambience enables a strong bond between the teachers and pupil, ensuring thereby greater attention to the instruction as well as education free of distraction and impediments. And yet, it is not as it is as secular, insular, as if the Gurukul is insular in nature. Students are encouraged to explore and expand their horizons and frontiers of their knowledge through broad internet facilities interacting both globally and nationally, which include sessions with the visiting speakers, dialogues with other educational and field studies. They have the advantage of being located to the Delhi and Jaipur both, as also Gurgaon. So they have the opportunity to have often frequent interactions with the judges of Honorable High Court and Supreme Court. True to the ideology of the founder, Raffles School of Law is dedicated to providing students with an excellent legal education embedded in humanistic traditions and values, to instill in graduates the ethical values, substantive knowledge, and practical skills they need to become effective advocates and compassionate counselors. Raffles School of Law provides conducive atmosphere for studies. School of Law believes in holistic personality development of the child as also to meet the contemporary expectation of the profession. Hence, exposure to the multidimensional vistas of knowledge is provided through expert lectures, field visits, industry inter- interactions, and moot court practices, as also the Nukkad Natak and the programs being conducted under the umbrella of Rajasthan Legal Service Authority and District Legal Service Authority with regard to the literacy and awareness in the surrounding areas. Moot court exercises are introduced from the first year itself as a part of curriculum. As a result, our students would bring that has been resulted in our students bagging first prize in prestigious DME National Moot Court competition held till now. 6 batches have already gone out with law degree who have made their alma mater proud by getting into excellent law firms, judiciary, and corporate Few who have gone to the litigation side are also doing an outstanding work. The curriculum is reviewed once in 3 years, followed by ideal pedagogy. Faculty members are available to each student 24/7, and this is a great advantage of being a residential institution. I would proudly say that two of our students have joined Rajasthan judiciary this year, Mr. Surjit Singh and Mr. Ravindra Solanki, very recently. The information center of the law school is very rich in terms of journals, textbooks, reports, and volumes, classics, and online materials. Westlaw and other online facilities are available to the children so that they can reach to any part of the globe. I am happy to note that our students and members of faculty are getting maximum benefit for their research work. The library opens till midnight so that those who want to really do the research and take advantage of the evening hours can also do that. The aim of School of Law is not to just produce advocates, but to produce upholders of the law, compassionate counselors with ethical values, meaningful members of the society, and capable officers of the court. I not taking too much time because everybody is wanting to know who has won the competition. So congratulating to the winning and wishing all the very best to the participants. I would say that hard work, sincerity, deep intellect, and adherence to the profession and professional ethics are the hallmarks of a lawyer's personality. By participating in these moot courts, you learn all these skills, what to say in the court and what not to say, and the court rules, etc., which I will encourage everyone who has not participated till now in the moot court should make it a regular practice. Here, I want to put some random thought on legal education also. There is no other learning under the sun which puts the wits of a man to test more challenging than the legal profession. Once a person earns a qualification in law so as to claim himself to be a professional, his time, his intellect, his words, and his wisdom, his competence and capability become saleable commodities in the market. Practice as much as articulation, practice as much as language, because they need practice. And how to convey your thought process to the court or to the consultant or to the client or to anybody you are giving advice to. I think that is the most important thing. Don't read only the law books. Please read something more than law also. Literature and other concerned subjects are as important as the law itself. Those who have participated and could not win also deserve my appreciation because they tried and gained experience, and that's a big achievement. I congratulate the winners and wish all the very best to everyone today. Enjoy the day and have fun. Thank you very much for virtually participating. And again, I thank my brother, Judge Mr. Virendra Kumarji, for having spared such a long time on Sunday afternoon. Thank you so much. Thanks a lot. Bye. Jai Hind.
Thank you so much. Thank you so much, ma'am. Accomplishment will prove to be a journey, not a destiny. With this quote, I would like to introduce a person who merely needs any introduction, as she is a very talented and hardworking personality. Professor Dr. Gadangi Indra ma'am. She is an excellent academician as she published about 8 papers in international journals and 15 national journals. Not only this, she was a keynote speaker and plenary speaker in Spain, United States of America. Over to you, ma'am.
Thank you, Yukti and the other coordinators. So, good afternoon, and with due apologies that the valedictory session is organized in the lunchtime, but anyways, it should goes on. And at the outset, I would like to thank our chairperson, ma'am, Justice Meena Gomba, because she has explained everything in a nutshell regarding the university, regarding the profession and everything. So at this juncture, I would like to extend my warm welcome to Justice Virendra Kumar. In spite of his busy schedule, he has amongst us, and your presence itself motivates our students. Thank you very much for sparing your valuable time, that too on Sunday, with us. And again, I would like to extend my heartfelt, warm welcome and thanks to Sri Preetham Surana from Surana and Surana International Attorney for his relentless support as well as friendly association with Raffles University in conducting such type of moot court competitions. I think this is the 5th one. So from 5 years onwards, you are associated with Raffles University. So I extend my heartfelt thanks to you, sir, for inspiring our young minds and total Indian students, law pursuing students. And I welcome all the participants to this valedictory session besides the organizers of the Moot Court Committee. And I congratulate all the enthusiastic participants who have participated in this 3-day Moot Court competitions organized in collaboration with Surana and Surana International Attorney with Raffles University. And at this juncture, I would like to congratulate all the participants because they have acquired the critical insight by dealing with the simulated moot court problem. And for this, the winning and losing doesn't matter because the experiential learning from where you have acquired the knowledge, how to write the arguments and everything, we know that learning by doing is always inspiring your minds and igniting your minds to write the arguments. And so it doesn't matter the winning and losing, but anyways, I congratulate each and every participants, but token of appreciation is needed because the hard work put in for the winners and the work they have done and exhibited, and then they have excelled their presence among in front of all the judges is really appreciating. So I congratulate all of them. As a token of appreciation, the prize is must for them to achieve more and more accolades in future. So thank you very much and all the best. And I think I congratulate even our organizers of Raffles University and everybody who have enthusiastically participated in this 3-day moot court competition. Thank you very much.
Thank you so much, ma'am. It is a pleasure to introduce our today's chief guest, Honorable Mr. Justice Virendra Kumar. Justice Virendra Kumar was born on 23rd May 1963. Sir has completed his LLB degree from Patna Law College, Patna, in the year 1986. His Lordship has practiced in various civil courts and Patna High Court. Sir was the topper of his batch in Bihar Superior Judicial Service examination, then joined Bihar Superior Judicial Services as an additional district and session judge in the year 1997. His Lordship has held the office of Registrar General at Patna High Court from the year 2011 to 2014. Before elevation, respected sir was posted as district and session judge in Patna. Sir was elevated as additional judge of Patna High Court on November 16, 2016. Further, his lordship was transferred to Rajasthan High Court and took oath on 3rd January 2022. It is our honor to have you, sir, with us today. Over to you, sir.
Thank you. Honorable dignitaries present in this August virtual gathering, dear students of this prestigious Raffles University, and all the participants from different prestigious institutions across the India, the people present here in different capacity to ensure successful completion of this Moot Court program. I am really very happy to be part of this valedictory function. I would like to appreciate tireless efforts of the organizers who created this seamless experience for all those involved in different capacity. I would like to express my gratitude to the management and organizers for successful completion of this Moot Court competition. As we all are aware, Surana is a brand platform to ensure enhancement of knowledge of the students and their advocacy skill. The organization of Moot Court competition provides enrichment of a skill for young legal minds to congregate and put their skill to the test. In the recent years, Moot courts have emerged as an indispensable part of the legal education. In our days, there was no such activity for the students, and we were forced to gain first court experience only before the real courts. Now, before reaching the actual courts, you are completely equipped with a skill of extensive research and environment of a courtroom. Therefore, legal institutions would be more benefited from the new generation than in the past. But please make sure that moot courts are not the actual courts. And there is a lot of difference in terms of pressure, tendency of cases, and consequences that can follow. You must be aware that the Constitution of India puts obligation in the nature of fundamental duties to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels for endeavor and achievement. Since it is your constitutional obligation, constitutional duty to enhance the excellence, you should be obliged to the institutions like Surana and Surana in reminding you about your duty by organizing such moot courts to facilitate enhancement of your excellence. Participation in any competitive activities aims towards excellence. Therefore, besides the winners, the participants also deserve credit and clap. Directly or indirectly, the participants as well as the audience to the program gets experience from the discussion made in the moot court. I had occasion to judge some of the moot court competitions in the Chanakya National Law University, and I have no hesitation to confess that I also learned from the students who were making submissions, not only the law, but also the manner of presentation of case before the court of law. Another fundamental duty is to abide by the Constitution. These are the fundamental duties enumerated in the Constitution. Human rights are part of the fundamental rights guaranteed under the Constitution of India. In fact, human rights are inclusive of many other rights. As we go deeper, the circle will get bigger and bigger. There is legal and institutional recognition that every person has dignity and value. human rights belong to each and every one of us equally. They are universal and inalienable. No one can voluntarily give up them up. You cannot give up the human rights, and nor can others take them away. Since everyone in this world has got human rights, its protection and honor by others is the duty of all of us, including the new legal brains. We should not only claim our human rights, rather respect the right of others. If we are correctly understand the legal importance of the human right, we can strive to protect the self-right as well as right of others, and we shall strive to protect and fight against any exploitation of human rights. This understanding would help to serve a larger purpose. Young law students are always competing against each other to do well in academics and eventually to secure good career opportunity. However, this spirit of competition should also be channeled by activities which give them better preparation for serving the needy people to protect their human rights. I am persuaded to speak a few words on human rights for the reason that your topic for moot court competition was also covering the area of implementation of human rights vis-a-vis the legal provisions permitting or not permitting employment in violation of the human rights. We are already running short of time. Therefore, with these words, I would like to thank all of you for bearing with me, and I would convey my best wishes to all the participants and organizers of this competition. I thank all of you for inviting me in this function. Thank you.
Thank you so much, sir. Winning is fun, sure, but winning is not everything. Wanting to win is the point. Not giving up is the point. Never letting up is the point. Never being satisfied with what you have done is the point. With this, we feel privileged in welcoming and introducing respected Mr. Preetham Surana sir, head of litigation and arbitration practice, and advocate and head of academic initiative Surana and Surana International Attorneys for his kind words, and declare the result of 5th Surana and Surana School of Law, Raffles University National Labor Law Moot Court Cum Judgment Writing Competition 2022. Over to you, sir.
Thank you, Ayushi. Chief Guest, Honorable Mr. Justice Birendra Kumar, Honorable Dr. Justice Meena V. Gomber, Chairperson, Gomber Education Society, Professor Dr. Gadangi Indra, President, Raffles University, Dr. Asif Ahmed Malik, Dean, School of Law, Raffles University, Mr. Mohammad Abu Said, Faculty Convener, Moot Court Committee, Raffles University, faculty members, scholars, staff, student conveners, Moot Court Committee members, students of School of Law, and my dear participants. My humble greetings and compliments to one and all. It is my privilege and pleasure to welcome you on behalf of our law firm, Surana and Surana International Attorneys, and further privilege to share my thoughts amidst this gathering at the valedictory of the 5th Surana and Surana and School of Law, Labor Law Moot Court and Judgment Writing Competition. Nurturing academic excellence has been an integral part of Surana and Surana for the past 2.5 decades. Our foray into organizing moot court competitions in association with top law schools and universities has yielded satisfying experience in helping improve research, writing, and advocacy skills of the participating students, besides sensitizing them in unsettled areas of law. Buoyed by the encouraging results, we expanded our activities with essay competitions in major areas of law and social sciences. Enthused by the overwhelming response, we then embarked upon judgment writing competitions, arbitral award competitions. The idea was to have a clinical approach to the issues at hand with an analytical mind and acquire the clarity to sum up the issues with a sense of just balance. In short, a comprehensive platform was created for the students to develop into a full-fledged legal professional. This landmark of having completed 25 years is an opportunity to convey our sincere gratitude to our Moot Court Advisory Board, which at various points of time have had distinguished members of the bar and academia, numbering about 50, our partner institutions numbering about 75, esteemed members, thousands of esteemed members of the bar and bench, again, thousands of the scholars and academia who have been guiding us and supporting us in our endeavor to provide students of law an opportunity to participate in the development of jurisprudence. While I was just listening to the speech which Honorable Dr. Justice Meena Gomber was mentioning, she was mentioning on the language. When she mentioned language, there was a thought which came to my mind that earlier this year, a galaxy of leaders from the bar, the bench, and academia gathered to deliberate on legal education, its present and future. Various points had come up, and we deliberated on majorly 4 points. Of course, there were many others, but I would just, since the topic of language came, I will just mention on the language and close my speech here itself, because the debate and the future of legal education itself was a full day and many points came forth. While all the beautifully educated people with elegant spoons in their mouth of grandiloquent words in speech or writing and sesquipedalian documents have been relevant, and we can still jargon on big, wonderful, pleasing Shakespeare, Chaucer, or Wordsworth vocabulary. The debate was of its relevance in the future. The changing face of society, which is based on inclusive democracy, particularly for people who speak English as a second language, people with disabilities, people with lower levels of education, indicates that the world will move to plain, simple, easily understood language when communicating. This stems from the fact that people have a right to understand what they are being asked to do, what their rights are, and what they are entitled to. It is ironical that we had a peep into the future within this calendar year. Last month, New Zealand has bid its farewell to jargon and introduced the Plain Language Act. The big question was to be or not to be. The B side, they got 65% votes, and the bill was passed with support from the Labour and the other parties. Henceforth, New Zealand will use plain language in its bureaucracy. Plain language advocates have said that the bill will save money and government time, and that clear communications are key to a functioning democracy. Other submitters argued that the bill would improve accessibility for people. Back home, the Society of Indian Law Firms have been propagating for the last 1 year the use of plain, simple language as well. Before I move on to announcing the results, it is again my privilege and pleasure to share with you that the Surana and Surana Moot Court project over the last 2.5 decades has now become the world's largest moot court program with more than 350 competitions. I will now move to announcing the results, which I'm sure the participants have been waiting. Most of the participants have had a very long day yesterday. I think we finished the rounds nearly by 10 p.m. in the evening. So we will first start the team category on memorials. Memorials are based on your preliminary round results. So with the fourth best memorial as the first announcement, this goes to Nisha Anna Joseph, Ina Fatima, and Mirza Ghalib from team code LL4, Vishnu Jayanti College of Law. Is the team here by any chance? As I announce the results, if any of the team members or their representatives are there, kindly come on camera and share if you have some few words to share with the others. Next is the third best memorial. This goes to team code LL7, the School of Legal Studies, Cochin University of Science and Technology, or QSAT as it is properly called, consisting of Shruti Jayakumar, Sara Novrin, and Nimya Feroz. Seems the participants are not available. Keeping again in the team category, but the positions, the two semi-finalists for team placed fourth and team placed third. So the team placed fourth is Swaminathan K, Shriya S, and Shri Abarna S from Shastra University, Tanjavur, with team code LL18. Congratulations, are you there? The team placed third is team code LL13 from Lloyd, which is the Lloyd Law College, Ayushi, consisting of Ayushi Saxena and Khushbu Kumari.
Thank you so much, sir.
And you can switch on your camera so all the guests and dignitaries present can have a view.
Thank you so much. Thank you so much, sir.
Coming to the individual category of the best student advocates. This is again based on your preliminary round results, where your aggregate raw points, that is your oral scores and memorial scores, were consolidated. The fourth best student advocate goes to team code LL18 Shastra, consisting of Shriya. The third best student advocates also goes to Shriya's teammate Swaminathan K. Both the fourth and third are from Shastra. The second best student advocates goes to team code LL11, the Alliance School of Law, Alliance University, Bangalore, to Mane Vaishnavi Roy.
Thank you, sir.
Can you please come up again? We haven't been able to see you. Yeah, that's Mane. Okay. You want to say something else?
No, sir. Thank you.
Okay. Being number 2 is a good place to be. Now for the best student advocate, who also gets a cash prize of 5,100. This goes to Advait Vitekar of the Army Institute of Law, Mohali, with team code LL15.
Thank you so much, sir.
Do you have anything to share in particular? You have been a finalist as well.
Right, sir. So it's been a very eye-opening experience throughout this competition. It's been really, it's really shown me another side of the ingenuity that I have inside me to be stitching up arguments as judges are grilling us. It's been an extremely eye-opening experience and a great learning opportunity. Thank you so much to all the MPC members, the organizing college, and to, of course, Surana and Surana attorneys. Thank you so much, sir.
Welcome. For your information, the 10th parameter, I think, on which you are graded is ingenuity. Just for your information.
Right, sir.
Okay. Now for the big prize, the winning team. This goes to Harshvardhan Yadav, Ankita, and Himanshi of Department of Law, Maharishi Dayanand University of team code LL12, who also get a cash prize of rupees 21,000. Congratulations to the team.
Thank you, sir. Thank you, sir.
Thank you, sir.
So the first people you must thank is your opponents. And that's the way I always say.
Surely. Surely, sir, surely. It's been a wonderful opportunity to argue whole court competition, sir. All the teams were equally. It's always been a neck-to-neck competition in each of the rounds, starting from the prelims till the finals.
Good. And now the runner-up team consisting of Advait Vitekar, Prataksha Roy, and Tia Pandey from Army Institute of Law, Mohali, team code LL15. They take home a cash prize of rupees 11,000 as well.
Thank you so much.
Congratulations. I have 2 more announcements to make before I wind up. That is, one is the best speaker of finals. The best speaker of finals goes to Department of Law, Maharishi Dayanand University, Harshvardhan Yadav. Congratulations, Harsh.
Thank you, sir.
We at Surana and Surana, the spirit we at Surana and Surana really epitomize the participative spirit in a lawyer who is supposed to have 4 traits. The team who follows 4 traits: the excellence of intellect and astuteness in argumentation, who participate in a spirited and healthy way. They have team solidarity and they participate in goodwill and harmony with other teams. Based on these parameters, we have decided to give this Spirit of Surana Award to Lavanya Panikar, Divya Thorat, and Kartik Patel of D.Y. Patil University School of Law with team code LL21. So that is the end of the announcement. I personally wish all the participants irrespective of whether they made it to the finals or not. The best in all their future endeavors, and Jai Hind. Before I wind up, I'm really sorry. I shouldn't be winding up like that. I have a lot of host of people to be thanking who have put in their efforts in organizing this competition, right from the judges, not only of the finale, but the other advanced rounds and preliminary rounds as well. The dignitaries present here for being here to end up the session in a very beautiful and wonderful way. The Honorable Dr. Justice Meena Gombar, Chairperson, Professor Dr. Gadangi Indra, President, Dr. Asaf Ahmed Malik, Mr. Ahmed Abu Sahid, the staff, the scholars who have been involved in this, student coordinators. I am likely to miss a few names because I'm not directly dealing with them, but the few who I've seen and have interacted, Nisha Gandhi, Vansh Dhingra, Shubham, Samriddhi, Yukti, Ayushika, and the other Moot Court committee members and student coordinators. And finally, two people I must thank, Dr. Arun Verma, the HOD School of Law, Raffles University, for this smooth proposition, and my colleague, Ms. Deepa Rajgopal, who actually takes all the burden and is a great help and source to conducting these wonderful competitions. He's been coordinating and working with you on this for months together. My thanks to all of you. Thank you.
Yeah, Pritam ji. Hello.
Yes. Yeah.
Pritam ji, whenever
Yes.
I say I'm in agreement with you, the language should be understood by the other person. When I say communicate means they should be able to convey what they are conveying, not going round, 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 round. This is what we have seen. Articulation and practice they need. So when I say, I don't mean any ornamental or flary or Chaucer or Wordsworth or anybody's language, but they should be clear, simple words, what they are conveying to the judge or to their client. It should be very brief, and that is what I meant was, sir. Thank you so
Correct.
much for
Yeah,
yeah.
that's
I
what,
know that I read in the lawyers also that there has been this going on the language thing, and I'm fully aware. But what I mention is that it is communicate clear. You know, normally enunciation is very bad. Sometimes the pronunciation is bad. What I'm trying to say to the other person, it should reach to the other person in the simpler words. And that is the best art actually to me. Sorry for taking, but I thought I must tell you, I never mean any language ornament. I'm very simple language always. Yeah. Thank you so much. Yeah, for updating also on this area going on. Thank you. Okay. So thanks everybody, my brother Virendra Kumarji. Thank you. Thank you, Gadangi Indra madam, and entire law team and all our students. Thanks a lot. Bye. Thank you, Surana ji.
our pleasure. Thank you, everyone.
Thank you so much, ma'am. Thank you so much, sir. What an outstanding session it was, full of enthusiasm, energy, a little bit of disappointments, but all above a small milestone of all the success and achievements coming in your way. With this, we are getting closer towards the end of our valedictory ceremony.
The root of all godness lies in the soil of appreciation for goodness, and no duty is more urgent than that of returning thanks. So, with this, we would like to call Dr. Asaf Ahmed Malik, Sir, Dean, School of Law, Raffles University, to deliver vote of thanks.
Thank you, Ayushika. Good afternoon to one and all present over virtually. First of all, I extend my sincere thanks to the Almighty God for making today's event a huge success. With His blessings and grace, we are able to make this event. As we come to the closure of the fifth Surana and Surana School of Law, Raffles University National Labor Law Moot Court Cum Judgment Writing Competition 2022. Respected chief guest, honorable guest of honors, all the dignitaries, participants, and dear Raffleians, ladies and gentlemen. I deem it a great honor to propose the vote of thanks to all of you on behalf of the School of Law, Raffles University, Neemrana, for such a resounding success of this event. We all are happy and grateful for this successful event. It is my privilege to thank our chief guest, Honorable Mr. Justice Virendra Kumar, Judge, Rajasthan High Court, for accepting the invitation and sparing his valuable time. I would like to express our gratitude for your blessings to us. We all are inspired by your words. Thank you, sir, for being with us in his auspicious day. I feel deeply gratitude and thanks to our guest of honor, Honorable Dr. Justice Meena B. Gombar, former Judge, Rajasthan High Court, and Chairperson, Gombar Education Foundation, for her consistent support and guidance, without which it was impossible to organize and make such a wonderful event. We are highly thankful to guest of honor, Professor Dr. Gadangi Indra, President, Raffles University, Neemrana, for her support and guidance and for providing to much value to our audience. Thank you, ma'am. I would also like to thank our judges of final round, Advocate Dr. Joseph Aristotle, sir, Advocate on Record, Supreme Court of India, Standing Counsel for State of Tamil Nadu, and Honorary Secretary, Supreme Court, Advocate on Record Association. Professor Dr. Aditya Tomar, sir, Director, Amity University, Noida, Advocate Anupam Bhati, sir, Advocate Supreme Court on Record of India, Professor Sanjeev Kumar Chadda, Head of the Department, School of Law, Legal Studies, Baba Saheb Bhimrao Ambedkar University, Lucknow, Advocate Mr. Shiv Kumar, Retired District Judge. Thank you all the judges of the final round and pre and quarter final round also. I further extend or we are very much thankful to our organizing partner, Advocate Mr. Pritam Surana and Surana International Attorney for helping us in organizing this moot court competition in collaboration with the School of Law, Raffles University, Neemrana. Thank you, sir. I would like to express our profound gratitude to Mr. Anil Sardana, Registrar, Raffles University, for his kind support. I have no words to express my gratitude for his participation and willingness to complete things outside of their comfort zone. I would like to express our deep sense of gratitude to all deans, principals, HODs, colleagues, participants, and dear Raffleians for their motivation and support. The synergy of our School of Law would not be complete without the energy and enthusiastic support of our students. I thank our young and talented student volunteers, convener of Moot Court Society, co-convener of Moot Court Society, and organizing committee of this event, who have worked out the round the clock for past few days. The office staff, technical staff, and workers of the department deserves our heartfelt thanks for their continuous support. Now, before I conclude, I congratulate to all the winners, my winning team, and best advocate 1, 2, 3, 4. And once again, I would like to thank everyone. I am grateful for giving me this opportunity with sincere and feeling of gratitude. Thank you, sir. Thank you so much.
Thank you so much, sir. We would like to take this opportunity to thank our revered Chief Guest, Honorable Mr. Justice Birendra Kumar Sir, and our Guest of Honor, Honorable Dr. Justice Meena Vigumbar Ma'am, and Honorable Professor Dr. Gadangi Indra Ma'am, and all the distinguished dignitaries.
We would like to take the opportunity to thank our revered chief guest, Honorable Mr. Justice Birendra Kumar Sir, and our guest of honor, Honorable Dr. Justice Meena Vigumba Ma'am, and Honorable Professor Dr. Gadangi Indra Ma'am, and all the distinguished dignitaries for the valuable time they have given to us today. We would also like to thank all the participants and everyone present here. You have been a wonderful audience, and we hope that we have been a good host to you equally. Once again, thanks to the hard work that all the team members have put in, teachers, students, organizers, and every team member to make this event possible. What you have witnessed is really their efforts and hard work. So with this, I would like to bring the curtains down for the valedictory ceremony and the competition. Thank you everyone. Jai Hind.